in the matter of David Rudolph, 23530. And appearance, counsel?
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client, consenting to the matter being heard via Zoom.
And Mr. Rudolph, if you can please state your name for the record.
David Dante Rudolph.
All right, thank you. Okay, today is the date scheduled for a jail review. Your client was sentenced in May of 2023 for disorderly conduct as assaulting and resisting an officer was dismissed. And he was sentenced to probation and 30 days on the alcohol tether. He was permitted to travel to Virginia for a funeral. Upon his return, there was a probation violation whereby he pled guilty on June 21st. The court sentenced Mr. Rudolph to 5 days jail, suspended that jail pending a jail review on August 28th. On August 21st, we held the jail review and adjourned it to October 23rd, whereby we were at the Court to Schools program. So we thought it appropriate to set it for today's date instead of the Court to Schools program. And so today is the date scheduled for the jail review. And Mr. Shemke?
Your Honor, I've had an opportunity to review the jail review. I saw the recommendations. I'd ask they be adopted. Nothing further from the defense.
And so, Mr. Rudolph, did you go test on October 19th as Ms. Shaw had instructed you to do?
Your Honor, it was an oversight. The first thing I do every morning when I wake up is check whether I have to report or not, because I have to plan, because I don't drive for obvious reasons. It was an oversight. I
understand
tested,
that. And that was the
one.
Excuse me, please, just one moment. I understand that October 17th was an oversight. I understand that, sir, which is why Ms. Shaw advised you to test on October 19th. Did you go test on October 19th?
Yes, in Lincoln Park on 4th Street.
Okay.
I filled out the paperwork accordingly. If you don't have it, it's not my fault. I have a receipt. I paid $25 to pee in a bottle.
Sir, I didn't say I didn't have it. I'm just trying to make a record. So I was asking if you went to test on October 19th.
All right. Was it negative or positive? Oh, Jesus. That's a problem.
What's the problem, sir?
What are the test results?
I'm looking in the file, sir.
I'm sure they're negative, as all of them have been. Your Honor, I respectfully want to address the court. I left my house at the age of 17 to join the military, to join the military police corps, because I love law, I love order. But what is going on in this country is the gross misconduct of justice. I respectfully ask you to release me from probation. I'll pay my fines, and I'm done with this circus. And it's not on you, it's not on the court. It's if my last name was Biden, I wouldn't be drunk in front of this court. Everyone knows it. If my last name is Trump, I'd be on the cross, crucified. And that's the only person that cares about this country. Because the Democrats and half the Republicans want to roll this country under the ground. And I've seen too many brothers and sisters die for this. And And that's all I have to say. Whatever you want to do to me, I don't care. I can. What's the balance of my? I'm not asking you to do it, but I've done it plus 10. I did 8 years in the military, and 100 days in jail doesn't mean crap to me.
Well, I appreciate your restraint in choosing your words carefully. And to answer your question, sir, your test was negative. And
thank you.
The court.
Please let me go. That's all I want. I won't step foot in line anymore. I'll pay you the couple $100 I owe you. Please leave me alone. That's all I ask. That's why I live in Monroe, because I don't want to see anyone. I don't want to deal with anyone. That's why I have 3 acres.
I can respect that. However, sir,
thank you. All right.
There is still a job that I have to do. And so the court had originally sentenced you to 18 months probation. You're eligible for early discharge. So you have a few more months to go if there aren't any violations within the next few months for you to request early discharge.
Ma'am, with all due respect,
yes.
That's not acceptable.
No, it's not acceptable?
No, it's not.
Okay.
I've earned the right to do what I want to do. And so what's the balance? So if I don't comply, what's going to happen? Oh, this is the part where my lawyer should speak up. My court-appointed lawyer, even though I paid $5,000 for Longton to represent me, and then he drops me because he's a shill. Shepke, got anything to say? Yeah, raise your eyebrows.
Nothing on behalf of the defense. Obviously, Mr. Rudolph has made his statements, and I still respectfully request that jail not be imposed. Thank you, Judge.
Thank you. Mr. Rudolph, you absolutely have the right to behave as you behave within the confines of the law and within the confines of this court's order regarding probation based upon the events that occurred on March 18th, which is why you're in front of this court.
Oh, because
sir,
I don't mean to.
Mr. Rudolph, Rudolph, please. I allowed you to say your piece, so please refrain from interrupting the court while I am speaking. With the exception of your use of alcohol on your trip that this court gave you permission to attend for a funeral for one of your comrades, if I recall correctly. Other than that, you haven't had any other violations. So the recommendation is for the jail review to be adjourned, to not impose the jail at this time. So that's what the court's going to do. I will also, sir, remind you that when you have your appointment with your probation officer, that is also an extension of the court. So appropriate behavior and language is expected. I don't mean to. Just one moment, please. Please let me finish.
I'm raising my hand like I'm in grade school. Go ahead, ma'am.
The communication that you have had with Ms. Shaw is less than stellar, and that cannot continue. The staff here do not need to be subjected to the language and types of communication that Ms. Shaw was subjected to.
Just when it seemed the hearing was coming to an end, the courtroom erupted once again. After the judge reminded the defendant that respectful communication with court staff was a condition of probation, the defendant immediately pushed back. He insisted that the First Amendment gave him the right to speak however he wanted and argued that no one could punish him for the way he expressed himself. The judge calmly responded that freedom of speech does not excuse disruptive behavior inside a courtroom. She explained that court employees deserve to be treated with respect and that abusive language and constant interruptions would not be tolerated. Rather than calming down, the defendant continued talking over the judge, repeatedly interrupting and insisting he had more to say.
I won't step foot in Wyandotte. This is ridiculous. You're going to make me a pariah. You're going to make me a pariah. And I'll do it. And I'll expose it. I don't care. You can't do anything to me that hasn't been taken from me. Do you understand that? Ma'am?
Sir?
That's it. I'm done. I ain't playing the game anymore. I'm not playing the game.
Listen, I am not going to have you yelling and screaming at me.
I'm not yelling and screaming. This is the way I talk. I'm half Italian. I'm sorry.
Well, let me also state this, sir. While there's a First Amendment right.
Right. I didn't pull a fire alarm. I didn't pull a fire alarm on the Senate floor.
Please let me stop interrupting.
I'm sorry, but I yield the time to Mrs. DeSanto.
Excuse me.
I yield.
My staff does not need to be subjected to that type of behavior. You want to speak? Excuse me. Stop interrupting, please. I'm just letting you know that behavior and communication will not be tolerated.
Despite the growing tension, the judge remained composed and focused on moving the case forward. Instead of ordering the defendant into custody, she chose to adjourn the jail review and even adjusted the next court date to accommodate his upcoming surgery. It was a decision that showed patience and restraint, even while the defendant continued challenging the court's authority. But the confrontation did not end there. As the hearing wrapped up, the defendant criticized the probation office over a paperwork mistake, prompting the judge to explain that it was simply a clerical error that would be corrected.